Hi everyone, you are warmly welcome to another episode of the Young Diplomats of Ghana podcast. I am Emenyo Nutakor and I will be your host for today. I have with me three very intelligent young people and I'd like them to introduce themselves to you.
Hi Emenyo, hi viewers. I am David-Kratos Ampofo. I am a lawyer in the Commercial Dispute Resolution Team at ENS.
Hi everyone, my name is Rene Kukua Essel and I'm a law student at the Ghana Institute of Management and Public Administration.
Hi everyone, my name is Emmanuel Akpagli. I'm a Part 2 law student of the Ghana School of Law.
Thank you all so much for joining me today. It's a very great honor to have you all here. Today, we're going to be talking about a very interesting topic, which is international law actually law? Now, over the years, there have been many wars and conflicts in which international law principles have been breached, and sometimes they've been breached with little to no consequences. And so there have been many conversations around whether or not international law is actually law that can be enforced. And if it can be enforced, does it apply to all states equally? So today we are going to address those issues, share our thoughts on how international law can be reformed, and most importantly, what we as young people can do to make the international law system a better one. So it promises to be a very exciting conversation. Relax and enjoy, and don't forget to subscribe to the Young Diplomats of Ghana podcast. So yes, let's get right into the conversation. But before we do, I believe it's important that we explain what international law is so that our viewers understand the context of the conversation. And so in very simple words, no legalese. I know I have a lawyer and I have two upcoming lawyers here, but in very simple words, can you please explain what international law is? I'll begin with you, David.
All right, thank you, Emenyo. So, international law refers to the rules that governs how states relate with each other. Also, it looks at how international organizations act, and also it seeks to ensure harmony or provide a certain system by which everybody is supposed to move with to ensure some kind of clarity on the international space.
Thank you so much, David. Essel.
Exactly, just piggybacking off what David just said. It's essentially the rule book that sovereign states use to guide how they relate with one another, and in some cases, how they relate with the citizens of their countries. And typically, in order to ensure their harmony, it compels these sovereign states to follow this rule book by providing sanctions or having other countries compel one another to comply with these rules in order to ensure global harmony and prevent global isolation as a whole.
Thank you so much for that answer. Emmanuel, can you share your thoughts on what international law
So
is?
just as it has rightly been said by my comrades, I think in a world of sovereignty and in a world where states exist, there needs to be a law that guides all of us and that governs us to be able to relate with each other. And that law is what simply international law is, to help us with our interactions and interrelations with states when it comes to trade, when it comes to diplomacy, when it comes to anything. So basically, international law is what guides us in our interactions among states in the international world.
So, Emmanuel, I'm going to come back to you. So in Ghana, we have sources of law, like the Constitution or the Act of Parliament. In international law, what is the equivalent? What are the sources of law in international law?
Yeah, thank you very much for that question. But before that, it's essential for us to understand that unlike in Ghana and unlike in the national world, where we have a vertical hierarchy of law, in the international world is horizontal. There really isn't any state that is better or that is superior to the other. Although in practice, that is what, in theory, that is what is. In practice, we see different things. Now to the sources of international law. One major or important source of international law are treaties, or what we term as international conventions.
Okay.
So this can include the UN Charter, for instance. It could even include the African Union's Charter. So these are treaties. It could be bilateral between two countries or multilateral between a lot of countries that they've come together to put down to govern their interactions. And these treaties are binding on the people that come together to form the treaties or that sign onto it.
Okay, so essentially only the people that sign onto the treaty are going to be bound by the treaty.
It depends.
Okay.
There are the kinds of treaties that, in an instance where you don't sign onto it, you are not bound by it. And there are some that are of customary international law practice or are of erga omnes practice for everyone to obey. So that brings me to the second source of international law, customary international law.
Okay, great.
So if you are not bound by a treaty, there are a lot of customary international law practices under the international jurisprudence that should guide your interactions with other states. Example include good faith. Example include pacta sunt servanda, which essentially is that if you say you are going to enter a treaty with anyone, you should be bound by it and you should follow through with whatever you've stated. So you can't enter into a non-proliferation of arms treaty with another country that you wouldn't bombard them and later go against it and do that. That is when international law must come in and deal with you. Another source of international law.
But in relation to that, could you kindly explain what customary international law is so that our audience understands?
Rightly so, apologies for that.
Oh, don't worry.
So customary international law simply borders on two grounds or on two stands.
Okay.
We have the state practice and the opinio juris. The state practice, in simple terms, is the constant practice of states that have generally become known or acknowledged by everyone. Examples are like for diplomatic relations, if any state official from another country comes into your country, you roll a red carpet for them to work on. There is no international provision or there's no law that stipulates or mandates you to do that. Yeah. But states have consciously been doing that for years now and it's become an acknowledged thing. So now everywhere, every time, when there is a diplomat or someone in another country, they do that. The opinion juris has to do with the intention. It is the understanding that there is a universal law that binds you to do it. Although it doesn't exist in practice, you think there is something that binds you or that gives you the obligation to do the state practice you are doing. So the rolling of the red carpets, everyone thinks, or the opinion juris is that they are bound to do it because it is good practice, because it shows that you are welcoming the other party. So that is the opinion juris. Okay. And essentially, when those two things amalgamate, that's what brings about the customary international law practices. There are other examples that would go on to mention as we talk. And lastly, the last sources of law for international law are general principles, judicial decisions of the international courts, and then writings of highly qualified publicists. And that too is a talk for another day on who exactly these highly qualified publicists are. But in sum, these are the sources of international law.
Thank you so much. So David, yes. Emmanuel just discussed a framework of law that exists under international law. But are states bound to comply with these laws at all times, or are there some laws that states are not bound to comply with?
Okay, so it's important we draw a distinction between the effects of international law. So there's hard law and there's soft law. So when we look at hard law is supposed to be those ones that bind states. But even within hard law, you have, for example, treaties. Before a party can be bound by a treaty, the party must have accepted to be bound by those terms. So the Vienna Convention on the Law of Treaties will tell you that there's privity when it comes to treaties. So that is, you must be a party to it before it will bind you. But as Emmanuel explained, you have situations where customary international law principles would arise would enter a treaty. And at that point, even though the treaty, you are not a party to that treaty, that customary international law principle applies to you. So aside treaties as hard law, we have customary international law also as hard law. We also have jus cogens. Now, jus cogens is those laws that the international community has seen to be of the highest level and of the highest importance. So when you have a rule of jus cogens, nobody can break it. You cannot even enter into a treaty to violate a jus cogens norm. So if Ghana and Togo agrees that they want to eliminate a certain race, that would amount to genocide. And the international community abhors genocide. So those parties cannot contract to do that. Now, at the same time, you have soft law. Now, soft law are those non-binding decisions, but then at the same time, they shape how the international community operates. So a recent example, I think on 25th March, was Ghana's resolution to declare slave trade as the greatest crime against humanity. So what that resolution does, and you probably would have heard some of the commentary, oh, but it's not binding, oh, what's the effect? It's shaping how we would treat slavery as the greatest crime against humanity in the future. So even though it's soft law, it's not binding, it will provide guidance, it will provide direction, and the international community will go from there. But I want to also add on to something on the customary international law. So when a rule of customary international law is developing, you can have soft law as the starting point. So you have these kind of declarations saying this is bad, this is not good, this is bad. And now states will say how they want to act in relation to it. So if a state doesn't want customary international law to bind it, that state would, for example, have to start objecting right from the start. So if you look at Ghana's resolution that I just referenced, the USA was probably one of the biggest the baddest people when it came to slave trade. And you'd see that because it has the potential of creating a rule on reparation, the USA has said no several times, and they have sought to ensure that, they were trying to, they voted against the resolution actually, and their ally Israel also voted against it. So you see that they are being a persistent objector because they are trying to prevent that rule from crystallizing against them.
Right. Thank you so much for that. So Essel, to you. In Ghana, we have institutions like the judiciary, executive, legislature, popularly called the three arms of government. I'm sure we all know that. So in international law, what is the equivalent of these institutions? What are the institutions that govern international law?
So as we all know, there are three main institutions, or the three arms of government that we have here in Ghana. The legislature, which basically creates laws, the executive, which implements them, and the judiciary, which enforces them in the country. But in international terms, the United Nations General Assembly can be what we define as the legislature. So here, all states have a seat in the United Nations General Assembly, and they vote and pass these laws, which become soft laws or hard laws. But most of what they pass isn't legally binding, as Kratos mentioned. It usually starts off as soft laws. And so countries are at liberty to ignore it, which means not include it in their laws if they are dualist states, or it automatically becomes part of their law if they are monist states. And then with the executive, we have the United Nations Security Council. So they can impose sanctions, or they can involve military action to prevent any breaches of peace. But however, when it comes to this, there are 5 countries that have veto power. That's Britain, France, China, Russia, and the United States. So with that, if they quote unquote misbehave, nothing essentially can be done because of the amount of power that they wield within that capacity. And then for the judiciary, the equivalent of that would be the International Criminal Court or the International Court of Justice. The International Court of Justice usually handles disputes between states, and the International Criminal Court handles disputes regarding war crimes such as genocide and other warlike crimes. But unlike our courts, where the judiciary can actually impose sanctions and arrest people, on the international front, on the other hand, these courts of judicature, when it comes to these matters, don't have any binding force on those countries. It depends on whether the countries themselves are willing to comply with that arrest, quote unquote. So, yeah.
So Essel, you've mentioned some very interesting things about how the decisions of the courts in the international system are not binding in a very high sense. And you also mentioned that sanctions can't be imposed on the permanent members of the Security Council. So in view of those comments, do you think that international law is being enforced at all?
I'm of the personal opinion that international law can't be enforced, because we've seen, as I mentioned, those 5 powerful states having veto power. If the people who are making the laws have the power to veto them, are they really at the mercy of the law? We've seen that those states are able to go scot-free on some of the worst war crimes that we've seen over time. And African countries, on the other hand, smaller states, on the other hand, they face the repercussions of these crimes at a faster rate. And so I think when the top dogs, when it comes to international law, are not at the mercy of the law, and the more marginalized communities are at the brunt of the law, we can't really call this international law enforceable if only a small minority group of its states are subject to it.
It's very interesting take. Thank you so much.
Rene, are we being fair if we say that because the enforcement regime does not apply equally, it is not existent or it is failing? Because in as much as it has its problems, we cannot also ignore the fact that it has its uses. And one, it's maintained world order since the end of World War II. Two, currently, the world is relatively peaceful in the sense that in as much as we have these 5 members who are aggressors in their own rights, they have also served to stall other aggressors. Even in Africa, you take Mali, 2015, and the role of the Security Council in bringing stability over there. I think that we should not be too harsh on our criticisms of international law, because it has major flaws like every legal system, but I don't think it takes away from what it is. It's just a flawed system, like how all other systems are flawed.
Yeah, rightly so. I also have a similar opinion,
Okay.
and a contrary one to Rene's position. I think it's selectively enforced. It's quite similar to what she's saying in the sense that it's enforced against the weaker states. And under international law, I think power is justice, and justice is not justice. The reason why there is the veto is, I think the veto has its downsides and its upends. The upends is that the veto gives the Security Council the ability to control these aggressors, as Kratos has rightly stated. The Security Council isn't something that can force the states to stay in. If the US says it wants out, it can go anytime, and it goes away with its funding. What would the Security Council do? If all these superpowers say they want out, we'll still go back to a world before World War II, where regional blocs would form and anyone can come and fight. I think principally people, there are still school of thoughts on whether international law is law, in the sense that because of its non-binding effects, because of its non-enforceability, they argue that it's rather morality and not law in the sense, as proponents like Jeremy Bentham and Austin have stated. But I think we should view it from the point of view that, what was the purpose? If it's still able to attain its purpose, as Kratos has rightly stated, to secure world peace, to secure security, I think to some extent it's law. Although there are a lot of flaws, I think we are in a world, is better than a world where the United Nations or international law does not exist. I think that world would be much more chaotic than the world we have now. Although there are still flaws, but at least the devil you know is better than the angel you know.
And Emmanuel, I think also as lawyers, sometimes we tend to think too much of form and over substance. So if you look at any real regime, right, you can't discount the effect of politics.
True.
Right? And it's the same on the international stage. And so you look at a country like North Korea. North Korea decided to use ballistic missiles to give itself protection, to equip itself with nuclear weapons so that other countries will be deterred to act. So it's a completely political move. Do you get it? So you can't discount the politics of it. The same way on the national level, we can't discount the politics of the laws we pass. Because recently we've heard of this paternity testing.
Yes,
it's a political issue. It's not a thing born out of law. Then at the end of the day, it becomes law and we would follow it.
I really love how the conversation has brought us here, especially talking about sanctions being imposed. Over the years, we know that the United Nations has imposed sanctions on many countries, including Iran, Iraq, Mali. However, Russia-Ukraine happened. So many states unilaterally imposed sanctions against Russia, but then the United Nations could not, because obviously Russia is a permanent member of the Security Council. So Rene, taking that into consideration, any other examples you may have in mind, kindly contribute to the conversation and tell us if you think that international law applies to all states. Because right now, we just had a conversation on if it can be enforced, who is in the process of enforcing it. But even in the enforcement, is it being applied equally to all states or not? And is that a good thing for us as a global space?
I think it's being applied equally to some extent. However, it's to the degree of the country's comfort of including that law into their laws. Overall, I don't think that's beneficial, because at the end of the day, yes, we're in a political world and every country seeks to serve their political interests, but waters become murky when a country's political interests are negative or at the detriment of another country. And so I don't think that's a very good approach.
David, I would also want your thoughts on this question.
Okay, so to a large extent, it's worked and it's not worked. Russia-Ukraine is an example of it's not working. But we've also seen, even with America, and I mean, when America and Britain invaded Iraq, for example, their justifications, we've seen how the Security Council regime and the sanction regime has applied unequally. But at the same time, too, for example, is the sanction regime that put pressure on the apartheid government in South Africa and allowed them to transition into democratic rule in 1994. So if you did not have the Security Council being able to impose such sanctions, you would probably have still had a South Africa today where whites and blacks are supposed to stay separate. So in as much as the sanction regime has its flaws, and of course, of late it's showing, I, for one, think that in the near future, we are going to see aggression from China, for example. You would have this situation where the veto countries can always stop the Security Council from imposing measures against them. But at the same time, it doesn't take away from the fact that the sanction regime does work. The flaw with the sanction regime right now is that you can't effectively force any of the 5 big superpowers. And I think we need to even have a conversation on that the Security Council is composition and even the present use of the veto power in today's world.
Yes. And I also think that sometimes when we are talking about enforcement, we limit ourselves to the Security Council. But even in relation to Russia, there was a vote to remove them from the United Nations Human Rights Council. So even if we aren't imposing sanctions on them, there are some repercussions for their actions. And so maybe in some way, international law may be applied equally or perhaps not. Yes.
Yeah. For me, I think I'm towards the contrary. I'm coming from the point of view of the third world approach to international law, which is presumptively known as a trailism. For them, they believe that international law is more of an imperial law. It's Eurocentric, and it's implied or it is imposed harshly on the global south. And it rather propagates Western ideas, in the sense that, for instance, the ICC, since its inception until 2016, it's always investigated African leaders. There hasn't been any investigation against any Western state leader since its inception till 2016, when there was one instituted in Georgia. We've seen instances where the US invaded Iraq. We've seen instances where neither George Bush, neither Tony Blair, or the persons who were at the helm of affairs, none of them were investigated. But in instances where there's some turmoil in Africa, you would see the ICC rush to investigate these leaders and to prosecute them. So from the third world's approach on, from their perspective, they believe international law isn't being applied equally to us all. And I think it's because we seem to forget the who factor, because who enforces or who applies the international law? As it stands now, I think it's a power dynamic. Those in power are the ones doing the application. And as Kratos has rightly stated, if they are the ones in power, we can't overlook the politics of things. They would definitely not do things that would go against their own national principles or nationalism. So I think rightly we can say it's not applied equally, but then again, at least the Security Council, the UN, tries to take steps, and it's these people that serve as blocks or breaker blocks for them to implement. But at least it does try to help curtail events when they do happen. And they should at least be commended for their proactive steps. But On the effects, I think that's a different story.
Emmanuel, while I am a proponent for changing the global international system to be more inclusive of the global south, I don't think I completely agree with the analysis to the point where, for example, when we talk about the criticisms that flow from the ICC's use of its jurisdiction, right? You cannot ignore the fact that we have mentioned earlier that treaties are the way by which you bind yourself.
That's true.
Internationally. If you take the Rome Statute, which establishes the International Criminal Court, the USA is not a member of it.
That's true.
Russia is not a member. China is not a member. Under the Rome Statute too, the ways in which the courts can exercise its jurisdiction, if the thing happened in a member state, or if it is referred by the ICJ, the Security Council, right? So you have these situations where the court can physically not do any, or the court actually does not have the legal authority to even exercise jurisdiction over these people. Because if, for example, you want to refer the USA's actions in Iraq to the ICC, and the Security Council wants to do that, all the USA will do is it will veto. Because of that, it will never get to the ICC. So clearly, yes, the power dynamic, because we don't have that political power, that's why you see African states going there. But also at the same time, too, we have to also recognize that ICC has not wrongfully exercised its jurisdiction over these global South leaders. There are people who, in their own rights, committed massive crimes, committed massive atrocities against their people. So for me, I think that the ICC, yes, it's applied to the global south, but I don't think it's been unfair. I think it's propagated its rule, and at the same time too, it's acted within the limits of the authority it has. If the USA wanted to be morally right and wanted to show that, look, we are actually showing that we don't want to be committing these kind of crimes, they would commit themselves to the statute, and then from there, now the ICC would exercise jurisdiction over them if they go and do something wrong. You get it? Yeah. So I see this whole conversation as right that the global south should play a bigger role on the international stage. However, I do not think that the ICC and some institutions of the international community are necessarily, let's say, targeting the global south, or not being fair to the global south, or paying more attention to the global south than others. I think it's a legal mechanism that has caused this.
Yeah, I think what he's saying is right and sound, but I'm also of the opinion that, or I also think, aside the US, there are other countries that are member states that have also committed atrocious acts. Maybe example, I don't have any examples of my mind at the moment, but I think as the records do show, between their inception to 2016, at least, there should be some other countries that should have come in between those times. However, the ICC didn't pay any attention to them, and that was right. But I think his argument is legally sound.
Thank you all so much. I'm really enjoying the conflicting opinions. So now let's bring it all back to us as African leaders, as young people who aspire to, one day become diplomats. We've identified that international law is flawed to a large extent, maybe not so much in the opinions of some, but very flawed in the opinions of others. Essel, I'd like you to speak on what we, as young people interested in diplomacy, can do. Should we opt out because we've identified flaws, or should we still go in with a goal to create some change, and how can we do that?
I think these flaws that we just talked about today should even be our main motivator for wanting to engage in these conversations. I think as we have a flawed system, we need more young people like ourselves. We need more conversations like these to encourage people to encourage ourselves, but also encourage the world to see that, one, Africans are actually interested in matters of diplomacy. We have a voice in matters of diplomacy. And also, diplomacy isn't just happening in the United Nations. Diplomacy happens on a small scale. When I speak to Emenyo about a policy being implemented that I don't like, that's diplomacy. And so I think we shouldn't enter because with a myopic view of it, or viewing it that it's flawed, but in a way that we can see ourselves as the change and be the change that happens from within that flawed system.
Thank you so much. Emmanuel, in a few seconds, can you share your opinion on this?
Yeah, so as she's rightly said, I also think the talk of the town brings change. When you face problems, I don't think it's best to run away from them. It's just best to face it head on. The solution comes easier than postponing it to another time. So as she's rightly stated, I think this is an avenue for African young leaders to get conversant with international diplomacy, with what is happening around them, so that they can also contribute to change. Even if not on an international level, right in their communities, because change starts from home. Charity begins at home. So even as she's rightly stated, diplomacy starts from our conversations personally,
Like this
on an
one.
intrapersonal relationship level.
Yeah.
And from then we'll build more and we'll be able to change or turn the international legal order. So yeah, I think as she's rightly stated, that's the way forward.
We've identified flaws. We've talked about what we as African leaders can do. But do you think there's a chance at reformation? And if so, how can that happen?
Okay, thank you, Emenyo. So, yes, there is a chance for reformation. International law can be reformed. I think that the way about it, and in seeking this reform, you should have the players who have historically not participated in international law participating in it. I like how now we see the activism of African countries. Last 2 years, we saw South Africa bring the genocide case against Israel. We saw Ghana's resolution this year. I know that both President Mahama and President Akufo-Addo have been involved in the push to get an African country on the permanent members of the Security Council. So I believe the reform in international law is happening through these conversations. And I believe that now that you have people who have historically been left out of these conversations, bringing themselves into the conversation, you have a chance at having a more equal political landscape. I also think that it's time for, especially us as Africans, to also leverage our political will and our political power. We have a lot of resources. We contribute to the global economy, and we should be able to combine that political power and our push for reform hand in hand to bring about the actual change.
Thank you so much. Thank you all so much. It's been a very wonderful, exciting, interesting, enjoyable conversation. I had a good time. I'm sure you all did, right?
Absolutely.
So to our lovely viewers, thank you so much for staying with us. Kindly subscribe, like this video, share it with your friends and family. Share your thoughts with us in the comment section. And from all of us here at YDG, we say goodbye and see you in our next video. Bye.
Bye.